Hello, my name is Jackie Denham and I'm an associate in the employment team at Field Seymour Park Solicitors in Reading. I'm delivering a series of 3 webinars regarding the General Data Protection Regulation and specifically how companies can lawfully process employee data under this new regime. This is part 3 in the series, focused on practical tips in order to ensure that you're in the best place possible to ensure compliance with the regulation when it comes into force next year. If you're interested in my overview of the general principles under the GDPR, you'll need to look at part 1 and 2 of our webinar series, which you can find on our website. So now that I've terrified you about why we need to be complying with our obligations and the extent of our obligations under the regulations in parts 1 and 2 of the webinar series, this section will be looking at the steps that you can take now to ensure that you don't need to worry about compliance. The initial step that we would expect you to take will be to carry out a detailed internal audit of your current data processing of employee data. That means you need to understand exactly what data you currently hold and process and why. Where is it being held? How long is it being held for? What systems do you have in place to ensure security of that data? Does any of the data need deleting or updating? What is your current lawful basis for processing the data? You need to understand if you're currently relying on employee consent as the lawful basis for that processing. You also need to look at what security measures you currently have in place. It is likely that this whole internal audit process will involve various members of different teams across your organisation, from finance, IT, HR, and many other different teams. How do you currently respond to the rights of data subjects, and how will you respond to the new rights if they're exercised? How do you respond to data breaches? And will you be able to comply with the new requirement to notify the ICO of any breaches within 72 hours? You also need to understand whether you transfer any personal data to third parties, and if so, which third parties they are, and the basis for transferring that data, and also whether that data ever gets transferred outside the EEA. Once you have an understanding of what your current data processing looks like, you can make some serious decisions about how you're going to be processing data going forward in compliance with the regulations obligations, and also what steps you need to take to ensure that you are compliant. You will need to decide what data you're currently holding that can be deleted because it's no longer necessary to process it, or you are unlawfully processing it. You also can decide whether any of the data you need to keep can be anonymised. If data is anonymised, it is no longer protected by the regulation because it is not personal data once it's been anonymised. You may also want to consider if any of the data you are currently keeping could be pseudonymised. This is a new concept which has been introduced by the regulation, and is basically where data has been amended so no individuals can be identified from it without having separate key information. For example, it's data that has reference only to employee numbers, and you couldn't specify who it relates to without having access to a separate secure document that has a list of the individuals against those reference numbers. We also highly recommend that you produce an inventory of your processing operations. This will help you comply with your records management specifications set out in the regulation, which I've described in more detail in part 2 of this webinar series. Essentially, it will be a large spreadsheet setting out for each type of your personal data processing exactly why it is necessary, where it is stored, where it is transferred to, why it is used, what your lawful basis for the processing is, how long it's going to be retained for, who has access to the information, and what security you have in place to ensure it is not unlawfully processed or accidentally destroyed You can also make decisions about records retention. Now, the legislation doesn't specify how long you need to retain your records for. Typically, we would suggest that in terms of employee personal data, there are some general rules that you can apply. For information and personal data relating to unsuccessful job applicants and interview records, these only need to be retained for a very short time, typically about 6 months. The only exception to this would be if you have a lawful basis for keeping, for example, applicants' job CVs, and you of course comply with your obligations in terms of informing them how long you will be keeping that information for, having a lawful basis for keeping that information, and obviously retaining it for no longer than appropriate. In terms of other employee records, typically we would suggest you keep these for up to 6 years after termination of the employment. This is because that is the limitation period if that individual brought a claim in a county court or high court. However, there's obviously the caveat that you may need to keep certain employee records for longer in order to comply with your obligations, for example, under income tax legislation or health and safety legislation. Or, for example, if you have collective workforce agreements in place, those need to be kept permanently. Similarly, if you have a works council minutes need to be kept permanently. You will need to make decisions about what data protection compliance program you will have in place. How will you comply with your obligations, and how will you demonstrate that you will be able to comply with your obligations? Also, you need to determine what your privacy governance structure will look like. Who in your company will have responsibility for ensuring that your organisation complies with its obligations under the regulation? So once you've carried out your audit and you've made your decisions about what needs to be done now in order to comply with your obligations, you will need to take steps to ensure that by May next year you have carried out all the actions necessary to ensure compliance. These steps are most likely to include the following: drafting, or at least updating, your general data protection policy. We would suggest that this sets out all your data processing activities across the company. You will need to be very careful if you currently have a contractual data protection policy, as you will need to be careful about how you implement any changes to that policy. It is likely to have to involve employee consultation. You will need to draft compliant privacy notices that set out all the information that must be included as set out in detail in the regulation, on which I've set out in part 1 of this webinar series. We would suggest that you need to have a separate privacy notice for your employees and perhaps any workers that work with you, and a separate one for external job applicants whose data will be processed in a very different way. You will need to check if you currently rely on employee consent as your lawful basis for any processing. You need to check that those consents comply with the new obligations set out in the regulation in order to be valid. If they do not comply, you will of course need to put new consents in place and obtain signature to those consents. You will also need to have in place a process for obtaining and effecting any withdrawal of those consents. You will probably need to review your current employment contracts. It is likely, and most employers do currently have in place, a general clause in their employment contracts specifying how they process employee data. This is likely to conflict with any privacy notice or data protection policy you put in place following the implementation of the regulation. If that is the case, we would suggest you probably need to consider making a formal notice to your employees stating that going forward after May next year, you will no longer be relying on that general clause in their employment contract as your basis for processing, and that in fact you will be processing their data in accordance with the new privacy notice and your general data protection policy. Related to this, of course, you're likely to have to update your current employment contract templates so that going forward they refer to your privacy notices and your general data protection policy. You are likely to have to review your arrangements with third parties if any personal data is being transferred outside the organisation. This will involve reviewing your contracts to ensure that they are compliant and that they ensure the third party is compliant with their obligations under the General Data Protection Regulation, particularly if the data is being transferred outside the EEA. We would also suggest that you, over and above checking your contractual obligations that are in place between the two parties, you carry out some actual due diligence to be able to demonstrate to the Information Commissioner's Office that you have taken appropriate steps to ensure the security of any personal data transferred. This would include asking the third party how they hold the personal data once transferred to them, if they indeed go on and share it with any third parties, and if so, how and on what basis. Asking them for copies of their policies, for example, on data protection, but also destruction of documentation. And also contact details of a person responsible at that third party, so that you have someone to contact in the event of a breach. You need to recruit or train a data protection officer if you're going to have one. And of course, anybody else who's going to have responsibility for complying with your obligations under the regulation. There are likely to be a whole host of internal processes which you will either have to amend or draft and then of course implement in order to ensure that you're compliant with your obligations under the regulations. These changes are likely to impact on your job applicant process, your process for making offers of employment, your internal processes for managing, deleting and amending employee records. For example, if someone has a disciplinary warning on their HR record that specifies it will be deleted after 12 months, then you need to make sure you have a process in place for removing that from their HR records. These changes are likely to impact on your tendering and negotiation processes so that you can ensure that any third parties have the right requirements in place in your contracts. It's going to impact the introduction of any new HR systems to ensure that the systems are compliant with your data protection obligations. You need to ensure your processes have been updated so that you can respond to any breaches within the 72-hour limit. And your processes will need to be changed so that you can respond to people exercising their data subject rights under the regulation, so that you can respond within the set periods for any requests for rectification of data or for any requests to withdraw their consent, and obviously any data subject access requests made. And finally, of course, you will then need to launch all your new policies and processes. Not only will this involve some communications to the relevant individuals and employees so that they understand what your new policy and processes are, but it will also involve any adequate training that needs to be carried out. Now, the training necessary will be very dependent on that individual's role and their access to personal data within your organisation, and of course their responsibilities under your data protection policy. So that's the end of our 3 webinar series. As I'd like to highlight, obviously this is only a brief introductory summary to the processing of employment data under the General Data Protection Regulation, and you should obviously take your own legal advice on your own specific circumstances, particularly if you process personal data of other individuals other than employees, for example relating to customers or clients, or potentially even vulnerable adults or children. I take this opportunity to highlight that our employment team carries out quarterly breakfast briefings. We also can run workshops on different employee subjects, and we issue monthly e-bulletins with updates on employment law. If you would like to receive information about any of this, please email me and I can arrange this for you. Please obviously get in touch if you've got any questions or feedback on this webinar series or any suggestions for future topics. You can find my contact details below.